So we've talked a little bit about international law in an anarchic system where there's no central authority to make or enforce international law. We talked a little bit about international courts, but again noted that this kind of operates differently than how international or how law operates within a domestic context within a state. And I'd like to talk a little bit about the enforcement piece as well, because that also operates differently than we would typically see within a state, but I think is still important to understand because there's a couple different ways that international law is enforced within the international system. So the vast majority of international law ends up being followed the vast majority of the time because of a mix of incentives and consequences and just a sense of reciprocity, that if I follow the rules, others will follow the rules, and if I don't follow the rules, they will respond by not following as well. And so a lot of trade agreements have built-in reciprocity elements to them that say, you lower your tariff barriers, other states will lower their tariff barriers, and if states don't follow through and meet their obligations under international law, you're maybe not required to as well. And so that operates in many international agreements, that principle of reciprocity. A lot of international agreements also involve a reporting system where you file a report and you communicate, yes, we are in compliance, we've done a review, we are doing these things that we're expected to do under international law. Here's our report that we send off to an international body that looks at it. Maybe they follow up with asking questions. Maybe another country comes in and does an inspection. But that reporting process, whether it's self-reporting or peer reporting, somebody else comes in and reports on you and says, yes, they gave me all the information I requested, and I saw clearly they're in compliance with international law. That can also spur states to follow international law, and when they're out of compliance with international law, to sort of get back in line with international law. And so none of that really looks like the way that we typically think about law enforcement with a domestic context, although I would note that a lot of law enforcement in a domestic context is a lot of just communicating to people sort of what the law is and encouraging them to sort of get in alignment with the law, to provide training, to provide reminders, to provide a structure in which compliance occurs. I'll pause with that. I could go on and on because my ex-wife worked in law enforcement in that capacity of education and coordination. Okay, so within the international system, there is also a enforcement structure that looks sort of more like what we traditionally think about when we think about enforcing law, and that's built into the UN Charter. And so there is a UN enforcement structure granted to the Security Council under Chapter 7 of the UN Charter. And under Chapter 7 of the UN Charter, the UN Security Council has the power to impose sanctions on states that are, endangering international peace and stability, and is even able to use military force against sovereign states to ensure that they're not destabilizing the international system. And under the UN Charter, when the UN Security Council takes action under Chapter 7, its decisions, its actions, its calls for contributions are binding on all states. That having been said, what I would call robust Chapter 7 action is relatively rare, and it is oftentimes done in conjunction with the states that are involved in the process, and is oftentimes done in conjunction with regional organizations, which are defined under Chapter 8 of the UN Charter, and oftentimes the UN Security Council really is just authorizing regional organizations to take action that they wouldn't have otherwise been able to take on their own. And so I want to kind of illustrate what this looks like with an example of a recent UN Security Council resolution. This is Resolution 2608 that was passed a couple years ago. And it begins with, I'm not going to show the whole thing or even talk through or read it, but I want to give kind of an overview of the structure of how these things work. It begins with what are called preambulatory clauses. And so preambulatory clauses all begin with an italicized word, and they're really setting the stage. And so the first italicized word is recalling. It's a very common sort of way to start out these Security Council resolutions. And it just simply lists all of the relevant previous resolutions that have been passed on this this issue. So it's putting it within sort of a larger context, right? Then it welcomes this report from the Secretary General that was recently filed. It reaffirms its respect for sovereignty. The UN Security Council, again, because it has this power under the UN Charter to kind of override sovereignty, is constantly reaffirming a respect for sovereignty and territorial integrity and political independence of states, because this is something that states are concerned about and want to make sure that is respected. And then welcomes developments that piracy seems to be on the wane within Somalia. And then it pivots to what are called operative clauses. And operative clauses have an italicized word and a number attached to them. And so I think importantly, this section begins acting under Chapter 7 of the Charter of the United Nations. Not every UN Security Council resolution has that wording. Sometimes they'll take action and they won't invoke Chapter 7, which is suggesting that what they're presenting is more symbolic, whereas here they're explicitly invoking these powers that the UN Security Council has under Chapter 7. And so it begins by reiterating that it condemns and deplores piracy. It notes improvements in Somalia. It stresses the need for comprehensive response to suppressing piracy. It underlines the responsibility of Somali authorities to fight piracy. It recognizes the need to continue investigating and prosecuting piracy, and it calls upon Somali authorities to interdict pirates, right? So again, we haven't really stepped on anybody's toes in the sense of sovereignty at this point. It's really just simply saying this is a problem that is primarily Somalia's to deal with, and we're emphasizing that Somalia has this role. It then pivots to another set, which are maybe a little bit more influential. No, that's not the right word. Robust, also not the right word. Well, we'll just talk them through, right? So highlights the importance of coordinating among member states and international organizations. And then it lists a couple international organizations that have sort of coalesced to address this. This is pretty common, right? So it's really green lighting that there are these other organizations out there that are involved. This is how states are coordinating, and the Security Council is giving a green light to that. Decides that a further period of 3 months from the date from this resolution, they'll renew a previous agreement supporting Somalia's fight against piracy. A lot of UN Security Council resolutions are simply rolling forward past practice. But what's interesting about this one is that they then follow up by affirming that authorizing this sort of international effort to help Somalia stop piracy does not constitute an establishment of customary international law. It's essentially saying this is an odd situation, and we're all recognizing that this is an odd situation, and we shouldn't assume that this is going to be taken as a new practice in terms of how the international system operates and isn't going to violate sovereignty. So they're explicitly pushing back against the idea that this could be a building trend, again, kind of constrain their power. And then decides that an embargo imposed in a previous resolution should be extended. So they have an embargo in place. That's a meaningful potential infringement on sovereignty, but they also have noted in 15 that they're taking this action because Somalia has requested it. And then finally, they call upon states to take appropriate action under existing domestic law and developed legislative processes to stop piracy. So this is a pretty good example of what a UN Security Council resolution looks like, right? Even though they're invoking Chapter 7 powers, it's very respectful of sovereignty, and where it does take action, it's oftentimes supporting other international organizations to take those steps, and oftentimes when it does actually take an action that violates sovereignty, it tries to stress we're doing this in conjunction with the state, or we're doing this in a way that doesn't set a precedent for the future because there's something unique about this situation. So when I say that strong Chapter 7 action is rare, that's partly what I'm getting at, but I'm also getting at the fact that strong Chapter 7 action is actively discouraged by the UN Charter, that the UN Charter is written with a progression of tools that are sort of built into it. And when it talks about how to deal with threats to international peace and stability and breaches to the peace, it talks about beginning the process of dealing with that, not with Chapter 7, not with the Security Council, but with Chapter 6, which outlines mechanisms for resolving disputes that are fully respective of sovereignty. And so it talks about negotiation, it talks about mediation, it talks about going to the International Court of Justice or using some sort of adjudication technique. It talks about working through those problems in a way that doesn't involve any sort of infringement on sovereignty at all. And then it says, okay, well, those things don't work. Then Chapter 7 may become relevant, and the UN Security Council can begin by taking steps to disrupt economic and communication links through sanctions. And only when it's been demonstrated that those kind of actions cannot resolve this issue, are not going to be sufficient, only then, when you've completely demonstrated those things have failed, can you take Chapter 7 action that would authorize military force. And so again, by its very design, the UN Charter is discouraging the Security Council from taking that kind of robust action. Now, there are some ways around that. In the case of Libya, during Gaddafi's sort of crackdown on protesters, there was initially a series of resolutions, and the UN Security Council decided that it could invoke and use military force against Libya to protect protesters. And it didn't have to go through this process of Chapter 6 and negotiating and mediating and bringing the ICJ. It didn't have to, spend 6, 7, 8 years using sanctions to try to dissuade Gaddafi from doing it. It could jump straight to military force. And the justification was that events on the ground are moving so rapidly that if you delay to allow this process to play out, it's unlikely that it will, the damage will have already been done. And so there have been times when that has been fast-tracked, but by and large, the vast majority of the time when the UN Security Council is bringing pressure to bear, it brings pressure to bear over the course of decades of an ongoing engagement, an ongoing pressure. We're going to ratchet up sanctions a little bit, and then a little bit more, and a little bit more, hoping that we can demonstrate that this will force some sort of negotiation process before having to resort to authorizing military force to stop a state from taking action that threatens international peace and stability. So I think that this is often the slowness of the Security Council, I think, is oftentimes frustrating to Americans who would like the Security Council to function as a vehicle for U.S. management of the international system, I will say, and frequently Americans critique the UN Security Council as being ineffective or deadlocked. And while that's true, it's true by design, that the UN Security Council was really set up to prevent rapid action that would threaten state sovereignty. It's designed to prevent action that would roll over the interests of other great powers. It's a system that's very much designed to protect states rather than to empower the override of sovereignty.